We're going to talk about when to stand your ground with your deadly weapon and when not to, next here on Due Process.
Major funding for Due Process is provided by Meade Lexus of Southfield and Meade Lexus of Lakeside, offering a large selection of new and pre-owned certified premium vehicles. It was the verdict heard round the world.
We, the jury, find George Zimmerman not guilty
In the shooting death of Trayvon Martin. The case put Florida's so-called Stand Your Ground law in the spotlight. Currently, there are 46 states that have Stand Your Ground or Castle Doctrine laws. Michigan is one of them. It's called the Self-Defense Act and was put in place in 2006. It allows an individual to use deadly force. Prior to 2006, an individual had a duty to retreat, meaning they had to try to escape the dangerous situation in their home before using force.
Thank you. I'm Henry Baskin, your host for this edition of Due Process. Thank you guys for stopping by.
Thank you for having us.
Really appreciate it.
Appreciate being here.
I really believe that the Michigan Stand Your Ground law, which some people never heard of before the Zimmerman trial, is a little fuzzy in its definition because I couldn't even answer the question of when you have to put away your weapon, when not to use your weapon, when you're justified in doing what Zimmerman did to Trayvon Martin. Is there a particular statute, a law that talks about it?
There is.
I mean, what is it? What is it labeled? Is it?
It's really in the category of self-defense.
Self-defense.
There's many cases in Michigan. The Michigan Supreme Court has actually addressed the issue. And what the Michigan Supreme Court has indicated, and there's a case called People versus Riddell, if, let's say, I'm subject to a sudden, fierce, and violent attack by somebody in the street, I'm walking.
How about in a bar?
In a bar, anywhere, really. It's sudden, it's violent.
Yeah.
I don't have to retreat. If I have a legitimate or honest and reasonable belief that I am in imminent or immediate danger of death or bodily harm, great bodily harm.
Could be bodily harm. Okay.
I have a right to use deadly force to protect myself.
Back in the day, weren't you taught that you had to flee, get away from the assailant as best you could?
Under common law, you had a duty to retreat in certain situations where it was feasible to do so.
A duty to get the heck out of there.
Right, unless you were inside your own home. If you're inside your own home, you never have a duty to retreat ever, even under common law. But under common law, yes.
Yeah, but let me just take that down for a second. So you wake up, someone's in your bedroom. Do you have the right to use your weapon?
Yes.
You do.
You do.
Absolutely.
But you're not in. Well, I guess you have to say, well, I'm in fear of assault or something.
The law sort of presumes it, actually.
Right. It's called the Castle Doctrine.
Yeah.
So there's a presumption
that
if someone's in your house.
The Castle Doctrine is the man or woman's home is their castle.
Okay.
And the presumption is if it's the middle of the night, whoever's in your house is there to do what? No good.
Or didn't
No
go
good.
home.
If they're bold enough to sneak into your house or walk into your house in the middle of the night, the presumption, as Melissa said, is that they're going to do some harm to you. And if you have a gun next to your bed and you shoot that person, you'll never get charged. It's self-defense.
So then you can use your weapon to protect yourself on the street.
Right. Well, it has to be an honest and reasonable belief. So if you're, and it also has to be somewhere that you have a legal reason to be there. You have to be legally allowed to be there.
Proximity has something to do with it.
It has to be a reasonable response to the assault. In other words, let's say a guy comes and punches me in the face, and I hit him back and I knock him down and he's down on the ground. I decide to duct tape him and I blow his head off. I can't do that, okay?
What, duct tape
because
him
then I become the aggressor, all right? So,
okay, so when there's, say you're in a bar, you have a bar fight, two drunk guys, and they punch and retaliate, and it's over. It stops right there. The right to shoot and kill someone.
Right. You can't chase them out the bar and shoot them because they beat you up.
Right.
Well, there's this common theme that people say, well, I believe that Michigan's law is that if you shoot somebody out in the street, drag them back in your house. and say, okay, this person was in my house. But you're saying you don't have to do
I
that.
think that's Texas. I think you got to go further south for that one.
You do criminal defense work,
Yes.
so have you ever used this law?
I see it mainly on appeals because I do a lot of appellate work. I think you've probably used it at the trial
I just
level
used it
more.
recently, as a matter of fact, in Farmington Hills, Michigan. I have a client, or had a client, and he was in his car, and it was on Orchard Lake Road, which is a very busy road, and there was construction there, and he was locked in, and he had his brake abruptly, and the fellow behind him started beeping the horn and making obscene gestures to him, and they go a little further. And then the guy behind my client decides he's going to jump out of his car. He attacks my client, and during the attack of my client,
He attacked your client who was in his car?
he was in his car, but my client couldn't go anywhere. He was locked into traffic.
Yeah.
And
He broke a window or
the other
something?
guy, the driver, we'll call him Joe.
Yeah.
Joe starts banging on the window and swearing at my client, telling him he's going to kill him. You know, he's going to F him up, he's going to kill him. And at one point in time, another guy who was about 6'5", 300, walks behind the Joe, and then Joe decides makes a motion to his side as though he's reaching for a weapon.
Yeah.
My client had a concealed pistol license, and he had a legitimate gun which was registered. And when the Joe makes his move, my client picks up his gun and he shoots Joe. He didn't
Did he
kill
kill
him, but he wounded him.
He shot him through the window?
The window was down a little
Okay.
bit. He shot him. And
So that was your defense?
self-defense, because my client had an honest and reasonable belief that he was in imminent danger of great bodily
Oh, and he had nowhere to go.
And the reasonable response to deadly force was deadly force. And the jury acquitted him. They found my client not guilty.
Well, I don't know how many people are walking around the state of Michigan with licenses, quite a few, I imagine, to carry concealed weapons. Can you shoot in the air? Can you do that? Or I don't know how people can process this. I'm being attacked. I'm being hurt. I think that if it continues, I'm going to be really in bad shape. So I'm going to shoot and kill someone. It doesn't have to be in an enclosed environment. It could be on the street. I'm not getting to the Zimmerman case and Trayvon Martin, but I'm saying, for example, parking lots, shopping centers, guy down the street the other day, he goes to his car, comes out of a gym, and somebody's under his car, pulls out a gun and says, give me your money and give me your car. Well, what right do you have to protect that? Now, you're trying to, you could say that you thought he was going to shoot and kill you, but he said, give me your money, give me your car. Is that okay?
Well, I think, the thing with self-defense is that anytime you have a claim of that, it's really fact-driven. So sometimes it's hard to say you can always black or white do this in this situation. But I think that if you're in a situation where, let's say, you are coming up to your car and you're going to get in your car, and there's some guy crawling out from underneath the car or out of the car who has a gun in his hand or who is asserting that he has a gun in his hand, and you honestly think that you are in danger of being attacked, then no, you don't have a duty to run away, and you can respond with whatever kind of deadly force is appropriate at
That's
that
a key
time.
word, deadly force.
And
Interesting.
here's the interesting factor in the law. If the man is charged with shooting this assailant who came at him, the jury has to judge the actions of the shooter, the guy who shot the robber,
Yes,
from the shooter's perspective.
from the shooter's perspective.
So in other words, they have to put themselves in the shoes of the man or woman that is asserting the self-defense. And it's not like, let's say, the Monday morning quarterback, where you'd say, well, man, that quarterback should have thrown the ball in the flat instead of down the middle. It's not a second-guessing thing. It's basically, it's the actions at the time, the circumstances at the time that the actor shot the gun.
So as lawyers, criminal defense lawyers, you have to paint that picture. Subjectivity. You're hearing the guy with the gun justify why he or she shot the weapon and hurt or killed this person.
Well, the person that shot the robber, who shot the person that was attacking him, if a self-defense argument or the self-defense issue is raised, then it's on the prosecutor. The prosecution has a burden of proof to show that it was not self-defense.
Well,
So the shooter doesn't have to prove it was self-defense.
Well,
the prosecutor has to prove it wasn't self-defense.
So the shooter doesn't have to say anything.
Well, the shooter has to allege that he was acting in self-defense.
Okay. So
Once you have a case like that and you're requesting that the judge instruct the jury on self-defense, all you have to do as the defendant is put forth some evidence that self-defense could be on the table.
and it could be a third party.
And yes, and then the prosecutor actually has to prove beyond a reasonable doubt, just as he would any other element of that crime, beyond a reasonable doubt that the defendant was not acting in self-defense.
And when you say a third party, the interesting thing is if I'm walking down the street and somebody attacks Melissa, right? And I believe that Melissa is in imminent danger of great bodily harm, I can intervene and do something to protect Melissa at that point in time.
Do you have to know Melissa?
No.
No.
It could be anyone. You're trying to protect you're a good Samaritan,
Yep.
and you're trying to protect
I
someone
have
from
an honest
harm.
and reasonable belief that that person is about to kill her, rape her, commit a violent crime on her.
Well, wait
I
a
can
minute.
kill
I
the
mean,
guy.
this sounds like the law west of the Pecos.
Well.
I mean, no, seriously.
It's
I mean,
getting pretty
you
wild
can
out
go out there and say, "Hey, she's being attacked. I can shoot and kill."
Well, I think
It depends.
Yeah, I think-
If she's
Well, no, I
being-
know that, but
she's being raped, I can kill the guy.
yeah.
You know, I don't want your viewers to let it think down. I say, oh, it's okay out to kill people.
No,
It's
I
not like
understand
that.
it, but
okay,
people want to know when and what they should do when they're under attack or being assaulted. And if in fact they can say, "Hey, help me," if someone's being assaulted and they're down and being pounded on, and someone say, "Hey, help me," can you do that?
It's what it would be the reasonable response.
Yes.
Okay,
If
so
a guy just punches me in the nose and I fall down, I can't just reach up and shoot him.
I go back. Then you lawyers have to paint a picture for the jury in opposition to the prosecutor, who has to do even more than you. But you have to paint a picture and put that jury, make them feel that they're in harm's way. Make them feel that, hey, if it were me, I would be
This is what I would have
using that
done.
or asking for help or something, which leads you up into that I don't want to call it anything but what it was, the Zimmerman case. Okay, we're going to talk about it later, but how did we get to the point of convincing that jury? And we're going to take a break and come back and talk about it for a moment, because it becomes a signal case in the states regarding the stand your ground principle, if that's what we want to call it. We'll be right back on Due Process. Stay with us.
Legal referrals and more information on this and other related topics are available on our website at www.dueprocess.tv. There you'll find information on today's program, helpful hints to legal issues, support materials, and lawyer referrals. You can also stream previous episodes of Due Process.
And now let's take a look at some of the issues.
I was in the military, so I understand rules of engagement, and we have to be fired upon before we're allowed to fire.
If you are physically threatened or about to be physically harmed, that you should protect yourself or get to a safe environment as quickly as possible. But if somebody simply raises their voice or you think that they're out to get you, a hunch just doesn't cut it anymore. So I think it's a bit extreme.
I think that the stand your ground law is a license to kill, considering they're not asking any questions, they're just going in with deadly forces.
Like what happened down in Florida a year ago with Trayvon Martin. Was it necessary for Zimmerman to shoot the young man? No.
We're back on Due Process. Thank you. We're talking to two criminal defense experts about the stand your ground, so to speak, law, which does exist in the state of Michigan. And I'm finding out a whole bunch. I hope you are too. Let me go back to the situation that occurred in Florida. I don't recall the perpetrator ever testifying in that case. Did you watch it on TV and know about
when
the
you say
case?
perpetrator,
I mean, the man who shot the kid.
Zimmerman.
Well, yeah, I'll use it.
Zimmerman, he did not testify.
He didn't.
And probably was an excellent move by his attorneys because he was acquitted. But my understanding of the Trayvon Martin Zimmerman issue was basically even though Zimmerman allegedly followed him and he was told not to, at some point in time there was an encounter. And at some point in time, Trayvon Martin, according to the evidence, was the assailant.
What was the evidence, if you recall?
I don't know.
Do you recall
I
the
wasn't in
evidence?
the courtroom. So.
I didn't watch the trial.
But I know that there was some type of an altercation, and eventually the evidence that was presented at trial was Trayvon Martin was on top of Zimmerman. He was banging his head against the cement, and that he had him in a very vulnerable position. And it was Zimmerman's position that at that time Zimmerman felt that he was in danger for his life.
Or his attorney's position was
Well,
that.
it could be his attorney's position, but it was...
There was a phone call or something.
Right.
But so the jury felt that way.
Correct.
But is the law more liberal in Florida than it is in Michigan?
My understanding of Florida law is there's no duty to retreat.
No
I think
duty
it
to
may
retreat.
be a little bit more liberal than it is here.
Right.
It is. I mean, because I've heard that legislatively they're going to change the law. Now, I'm not certain if that's going to solve the problem, but it seems as if a lot of people, they're taking sides in this thing. They're calling it a racial issue. They're saying that the law is wrong. It has to be changed. And if in truth and in fact someone is in fear of their life, they should have the right, because you only have one of those,
But
one life. You have the right to defend yourself.
But the caveat there is if it's a situation where somebody can retreat and it's not a sudden violent attack, it has to be a sudden violent attack, a fierce attack on you. And then at that point in time, you have no alternative because it's a sudden attack and you're in imminent or immediate danger.
Okay.
If it's a situation where, as Melissa said, you're being threatened, now I'm going to do this to you and do that to you, and you can walk away from it, you can't pull a weapon and shoot a guy.
Okay, but my personality is different than his personality. So I'm a wimp, and he's a tough guy, okay? And as a wimp, I could take a punch and think, whoa, I'm going to get killed. Mitch could take a punch and say, hey, let me give you one back. So does the jury process that and say, well, I'm a wimpy guy, and I thought I was going to get my butt kicked, and toward the end of killing me, and Mitch is a different kind of guy. Do they assess that at all?
Well, they assess what's reasonable. I mean, I think that the law is written to try and avoid the whole Wild West, that kind of thing,
right,
by injecting the requirement that your reaction be reasonable.
Mm-hmm.
And I think that if you're being assaulted, then it's reasonable to respond with that kind of force in kind.
Okay.
Henry, what you just said, your answer to that question is yes. Let's assume I'm 64 years old, okay?
I didn't ask.
Yeah, okay.
No, you're like 20.
Right, I'm on Coumadin, all right, and I've had some health issues, right? So some guy busts me in the head, okay, and because I'm on Coumadin, there's a strong likelihood that I could die from that because, you know,
keep bleeding,
right, bleed out and all that kind of stuff. And at my age, I'm not the way I was at 25. So, yes, if I'm older and I have infirmity, I'm infirm with certain types of things or disabilities or medications, yeah, that is taken into consideration.
Okay.
Because a guy who's my age or your age, we're not going to sit down there and fight a 25-year-old guy who's 6'2", 200 pounds, who's in the gym every day.
Well, let's not tell them that. Let's tell them who we are. But let's talk about this new issue called road rage. I mean, I'm going to tell you something. That's pretty scary. Women driving home from work at Beaumont Hospital on the freeway gets cut off, and some maniac is coming back and saying, okay, open your door or whatever. Now, where do we go with that? Because there's more road rage than I've ever heard in my life. I mean, it's amazing. How intimidated. See, you described a situation where the guy had no exit. He couldn't move his car. And here's a woman who can't move her car. Now, what is she required to do? I mean, say she has a weapon. Can she use it if the facts are as you say?
Well, it gets back again, and there is some ambiguity, as Melissa said. It's the reasonable and honest belief that she's in imminent danger of death or bodily harm. If she has no escape route, she can't get away, and the guy's pulling at her door and trying to get the door open, or he takes out a crowbar and smashes her window out. At that juncture, if she honestly believes at that time her only alternative to save her life or to prevent being
attacked,
her face busted in, her nose broken, and that sort of thing,
right?
She in all likelihood, has the right to defend herself.
If she
even
has
with
a
deadly
weapon.
force. Correct. Because she's subject to that sudden, fierce, violent attack, and she has nowhere to go. So she has a right to stand her ground right there.
Well, I mean, we're not recommending
No.
people do this, but what we're saying is that these sudden attacks, and I think it's sort of a key word, those sudden vicious attacks, could lead to you using your weapon if you have a weapon, or doing something with your car or whatever.
Running the guy down, if you
Yeah,
have to.
if that be the case. Now, in the Zimmerman case, very recently, the attorney said, well, we want money. The defense lawyers said, we want money from the state of Florida because we have $300,000 in exhibits and expert witness fees, and we want the state to reimburse us. Is that a reality in Michigan?
I think there's a Florida law that allows them to, I just read about that. I think there's a Florida law that allows them to ask for that kind of reimbursement when the defendant has been acquitted. I don't know that we have that here.
I'm not familiar with
I don't
any
think
such
we
law
do.
in Michigan.
Okay, so you're defending someone. You just had a major case, for example,
Cipriano.
the Cipriano case. It was a major case.
It was.
He got a lot of notoriety, a lot of publicity, so forth and so on. But if he would have not been convicted, you're not going to ask the state of Michigan to help pay your fee or pay for the exhibits and demonstrative evidence because it doesn't exist in Michigan.
No. Well, if there's some police misconduct involved, then you might have a lawsuit. When I say police misconduct, there was some malicious behavior.
Yeah, but
trying to
that's the
frame
point
somebody.
I'm getting
That's a whole
to. The
different
point is
issue.
that they say Zimmerman was overcharged, that he should never have been charged the way he was by the prosecution. What happens in that case? Does it happen in Michigan? I'm sure it does.
Sure, it happens all the time.
Yeah. Can you sue the prosecutor? Can you sue the attorney general?
No, prosecutorial immunity.
They have immunity, so they can charge a misdemeanor up to a murder one or a felony murder count.
Well, I think there's exceptions to the
Yeah.
immunity. I think if the defendant or whomever is charged can demonstrate that it was a willful, malicious prosecution and that there was no real basis for that prosecution, then he probably has some type of action.
Okay, this complaint. I mean, you can't comment on other people's cases specifically, but in that case, they were criticizing the prosecutor. I mean, they really blasted the prosecutor.
Well, I think part of that was because initially the prosecutor's office declined to issue a warrant or to press charges against Zimmerman. And when the public outcry began, then they changed their opinion.
Well, let me take off your badge as a criminal defense lawyer, both of you. Okay, what do you think? What did you think about that case?
I thought that if that was what the jury decided, then the prosecutor probably didn't have it. I mean, that was what I thought.
So you're saying they couldn't prove him guilty. You're not saying he wasn't guilty.
I mean, we never know. We weren't there.
Okay.
Right, that's the problem. We're always asking.
Yeah, no,
what do you think of that?
Well, you know, these talking heads on
right,
television,
right.
these people have an expression, a feeling about everything.
Right.
Let me tell you about the Pistorius case. I mean, that case involved, you're aware of that case, Pistorius, the man who is a double amputee. He's a runner. He shot and killed
in South Africa.
shot
Yes.
and killed his girlfriend, saying, I thought someone was in the house. And, we don't know all the facts of that case, but is that the same kind of thing they're trying to do, say self-defense?
I think that's going to be a hard sell. I think what it really is it's a mistake. I don't know if it's really a self-defense.
So is that a crime?
Well, mistake could be a defense. Okay,
Mistake could be a
he was
defense?
mistaken that there was a home invasion going on and that there was a burglar in his house and that he shot the burglar.
Yeah, but he wasn't being attacked. We know that he wasn't being attacked.
Well, it gets back to the old castle doctrine that if somebody's in my house in the middle of the night on a break-in...
She was living with him.
Well, I understand. That's why I'm saying.
know.
I'm saying it's kind of a shaky defense, and maybe they have no other defense. And I understand from. Go ahead.
Question because we're running out of time. A question for both of you. The client says he's guilty. She's guilty. Client says they're guilty. You go to court. You try to convince the jury that that person is not guilty. And people say, how can you be a criminal defense lawyer when you know that person committed the crime? How do you answer that question?
How many times have you been asked that question?
A lot.
Yeah, well,
Want to take it first?
It's, you know what, it's our job, which sounds like sort of a flip answer, but it's our job, and we're there to make sure that everybody's constitutional rights are protected.
It gets down to constitutional rights. It gets down to what, Mitch? Whether the jury proved beyond
reasonable doubt.
Reasonable doubt.
As along the lines of that question, if a client tells me or tells Melissa that, look, I did it, we cannot put him or her on the witness stand and let them perjure themselves. They can't get up and say, I didn't do it. They're done. But there's nothing that prevents us from making the government prove the case beyond a reasonable doubt. And sometimes, if the prosecutor's office is not reasonable with respect to a sentence agreement or something, a lot of these guys have nothing to lose, and we end up having a trial.
You guys have tough jobs.
Yeah,
when I was back in the day doing criminal work, I said to my client, you were arrested at the corner of Woodward and Grand Boulevard. He said, no, I wasn't, because I wasn't there. Is that your defense? He said, yeah.
Major funding for Due Process is provided by Meade Lexus of Southfield and Meade Lexus of Lakeside, offering a large selection of new and pre-owned certified premium vehicles.